Having said that, let me recognize Representative Rokita, my good friend from Indiana, for your 5 minutes of questioning.
Thank you, Chair. I appreciate that. Appreciate you holding this hearing, and I thank the witnesses for their testimony this morning. I'm going to concentrate, at least initially, on Mr. DeCamp. Thank you for your service to this country, by the way. Your written testimony, if I understand it right, highlights an issue that employers face when determining an employee's regular rate for the purposes of calculating overtime pay. And having been an employee in some of these places and then knowing other employers, I know that a lot of employers try to do the right thing by, offering their workers, allowing them to share in the success of a company through a bonus structure or some kind of equity or non-equity provision, mostly non-equity. Yet even this well-intentioned action can result in an employer running afoul of the FLSA, or it can be a deterrent to employers who want to provide bonuses. Can you elaborate for about 30 seconds to a minute on that?
Well, sure. What we're talking about really is one of the regular rate exclusions under the statute. And under the FLSA, a discretionary bonus does not have to go into the regular rate, so the employer does not have to pay overtime on top of that bonus. A non-discretionary bonus, however, does go into the regular rate. If an employer guesses wrong as to whether a bonus is discretionary or non-discretionary, it can find itself after the fact, after it's paid bonuses, subject to an enforcement action. There's a great example of that. There's an oil and gas company in the Southwest that awarded bonuses that it regarded as discretionary under the standards and the regulations to about 5,000 of its non-exempt employees. The Department of Labor came in afterwards and said, no, we think that was a non-discretionary bonus, and in fact you have to pay overtime on that. This resulted in the Department of Labor filing a lawsuit in federal court accusing the company of violating the law with respect to over 5,000 workers.
Yet these people got bonuses.
They got bonuses. This is sort of the no good deed goes unpunished theory of employment. Right. And this led to litigation and ultimately a large award.
Well, surely the company explained and showed that, consideration was given, and I don't know if it was less or more, but let's assume it was about the same, or you tell me if it's different. And what was the department's response? A lawsuit? And then what was their legal argument?
The department's
strict noncompliance?
The department's argument was, well, look, you gave this benefit to just about all of your people. You've given this bonus before. Therefore, even though you retained, under the terms of the bonus plan, the discretion not to award a bonus, we're going to treat it as non-discretionary. We're going to say that you really were promising to give this money even though you said you didn't have to give it. And so the department said it goes into the regular rate, and they sued.
What adjective would you use for something like this, an action like this?
I'm sorry, say again?
What adjective would you use for an action like that?
I can't say it in this room.
I'll church it up. Go ahead.
No, it's heavy-handed and punitive. And
I was going to say punitive. Absurd might be, going on with something else. I assume you might be aware of an amendment that was recently filed here in the House of Representatives during a floor debate on several appropriations measures. I was surprised by it, actually, but the amendment would prevent contractors found to have violated the FLSA from continuing to receive federal contracts. So can you explain how this amendment could impact companies that you have experience with, where through no intentional action, they would again punitively be prohibited from getting employed by the federal government?
Well, a great example is that same oil and gas company I was talking about. They happen to be a federal contractor. So under the standards of the amendment, that company would arguably be barred from federal contracting. It would be blacklisted under the Appropriations Amendment because there was an award that was in excess of whether it's 5,000 or 100,000, depending on which provision of the statute we're talking about. It was a six-figure award ultimately. That company, that their only violation was paying their non-exempt employees too much, giving them bonuses, could result in them being kicked out of the federal contracting program.
Okay. Is it also true in your experience, both as a private practitioner now, but in your public experience, that union contracts are tied to minimum wage rates?
They can be. They're not always. It depends on the contract.
You have a 1 out of 10. How many would be? Any kind of?
I wouldn't be able to estimate. Frankly, most union jobs that I've seen are well above minimum wage, and so tend not to.
Anyway, right. Okay. All right, fair enough. Mr. Chairman, thanks for the time again. I yield back.